Good morning, this is the Kelso Report for Monday, January 23rd, and I'm your host, Clark Kelso. We start with a Supreme Court decision under the Voting Rights Act. Now, under the Voting Rights Act, certain state and local districts are known as pre-clearance districts, where changes in electoral policies or practices must be cleared by the United States Department of Justice before they can come into effect. When such changes are made too close to an upcoming election and DOJ does not have time to complete its pre-clearance analysis, a district court may have no choice but to try to draw interim district lines. That is what happened in Texas, and the district court's interim districts were reviewed and reversed by the Supreme Court in Perry v. Perez. The Supreme Court's concern was that the district court appeared at times to entirely disregard the draft map which had been promulgated by the legislature and submitted to DOJ, even when there appeared to be no constitutional problems with portions of the map. According to the court, the district court should have followed the policies and choices expressed in the legislature's draft map, except when those choices created an unconstitutional condition. As the court explained, quote, "To the extent the district court exceeded its mission to draw interim maps that do not violate the Constitution or the Voting Rights Act, and substituted its own concept of the collective public good for the Texas legislature's determination of which policies serve the interests of the citizens of Texas, the court erred," close quote. We have a number of decisions from the Ninth Circuit to take a look at today. First, in the area of Indian law. Section 1153 of Title 18 provides that certain crimes committed by an Indian on another Indian in Indian country will nevertheless be tried in federal district court. The defendant in United States v. Juvenile Male argued that he was not covered by Section 1153 because he does not consider himself Indian and has no social recognition or acceptance among the tribe, even though he is at least 1/4 Indian by blood, is an enrolled member of the tribe, resides on the tribal reservation, and used his membership to receive benefits available exclusively to tribal members. Well, the Ninth Circuit held that given his Indian blood and the other factors establishing that he took advantage of tribal membership, the defendant was clearly an Indian for purposes of Section 1153. Next, in the area of church and state, the religious practices of inmates are protected by federal law, by the Religious Land Use and Institutionalized Persons Act, pursuant to which an inmate can secure appropriate declaratory and injunctive relief if their religious practices are substantially burdened without sufficient justification. The Act does not provide a damage remedy against state officials sued in their official capacity because of the state's sovereign immunity. In Alvarez v. Hill, the Ninth Circuit affirmed the dismissal of a former inmate's claims under the Act because the Department of Corrections had released the inmate from custody, mooting out the remaining claims for injunctive relief. The court rejected the capable of repetition yet evading review exception to mootness, noting that it would be speculative to find that the plaintiff was going to commit another crime and be recommitted to corrections. Next, in the area of commercial transactions. Now, it often happens in a big transaction that one party wants some additional guarantee of performance in addition to the other party's promises to perform. In 614 CRM Collateral v. Tri-County Metropolitan Transportation, the buyer of light rail cars required the manufacturer to obtain a $3 million standby letter of credit, so that if the manufacturer defaulted on the $17 million contract, the buyer would have recourse to those funds. When the buyer certified the manufacturer's default on the contract, the obligor on the standby letter of credit tried to interpose a defense of discharge of the underlying obligation, claiming that the standby letter of credit actually made the obligor a surety who was entitled to assert defenses the manufacturer might have. The Ninth Circuit correctly rejected this argument, holding that the obligor's obligations were defined entirely by the standby letter of credit, and a letter of credit is not a guarantee and does not create a suretyship. Next, an important education law issue, which arose in the Ninth Circuit, and they are now certifying to the California Supreme Court. Special education services can be very costly to school districts, and it was with that reality in mind that the Ninth Circuit in Los Angeles Unified School District versus Garcia has certified to the California Supreme Court the following question of state law. Quote, does California Education Code Section 56041, which provides generally that for qualifying children ages 18 to 22, the school district where the child's parent resides is responsible for providing special education services, does that apply to children who are incarcerated in county jails? Close quote. Well, depending on the answer, LA Unified may be responsible, or perhaps a different county will be responsible, or LA County, or perhaps the Board of Education. So the ball has been passed to the California Supreme Court for resolution of this expensive question. Next, we turn to some California Court of Appeal decisions from late last week. First, in the area of family law. To become a presumed parent under Section 7611 of the Family Code, an adult must show that he or she has received the child into his or her home and openly holds out the child as the adult's natural child. Evidence of the relationship between a purported presumed parent and the child's other parent may have some relevance to that determination, but the focus should be on the presumed parent's relationship with the child, not the other parent. In EC versus JV, the 3rd District then reversed and remanded, so the trial court could use the proper legal standard in analyzing whether the plaintiff was a presumed parent. The trial court had rejected plaintiff's contention, but did so primarily because the plaintiff and the other parent had never taken formal steps to recognize their own relationship. They never registered as domestic partners, did not decide themselves to have the child was from a prior relationship, did not live together after the child was born, and so on. As the court explained, the lower court considered irrelevant facts in determining the plaintiff's status, and to the extent the court considered relevant facts, the court considered them only in assessing the couple's relationship, not in evaluating how their relationship may have demonstrated a commitment to the child. The court remanded for redetermination in light of the proper legal standard and focus. Next, in the area of civil procedure, the Mentally Disordered Offenders Act, which was enacted in 1985, protects the public from and helps provide treatment for prisoners with dangerous, treatable, severe mental disorders. A prisoner who's adjudicated to be an MDO may be civilly committed during and after parole if certain conditions are met. Once determined to be an MDO, the patient is committed to the jurisdiction of the Department of Mental Health and the Department of Corrections and Rehabilitation for determination of appropriate placement in a state hospital. In People v. Graham, the trial court determined that the inmate was an MDO, and then the trial court made a determination about whether he should be housed at Napa State Hospital or at State Prison in Sacramento. The 3rd District held that once the court decided he was an MDO, a determination not challenged on appeal, the trial court should have simply committed him to the jurisdiction of the Department of Mental Health, for the department to make the placement determination. The court also held that the proper procedure for challenging a placement decision was for the patient to file a petition for a writ of habeas corpus. Next, we turn to questions of appellate jurisdiction. Now, as we know, it has become increasingly commonplace to find arbitration clauses in employment and consumer contracts that, among other things, attempt to prohibit the maintenance of class actions. The 1st District faced just such a clause in Reyes v. Macy's, but did not reach any of the merits because none of the orders below were appealable. The trial court had granted Macy's motion to compel arbitration of the plaintiff's individual labor law claims regarding payment for overtime and such, but refused to dismiss class allegations and refused to compel arbitration of those claims. Macy's filed an appeal. Well, the First District held that the order compelling arbitration was not appealable by Macy's since Macy's had filed the motion for that portion of the order, and a judgment granting arbitration is not appealable in any event. The order denying Macy's request to dismiss the class allegations was also not a final judgment and was not appealable. Macy's argued the trial court's order was tantamount to a refusal to order arbitration. Now that would be an appealable order, but the appellate court rejected that argument, since that is actually not what the trial court did. So Macy's appeal is dismissed, and now they've got individual arbitration of one claim, but they've still got those class claims standing in the Superior Court. If Macy's wants immediate review of the decision not to dismiss the class allegations, it'll have to try a petition for a writ of mandate, and that, of course, is something the appellate court can simply deny as a matter of discretion. So Macy's has a big long shot to get immediate review, and it looks like that class action will proceed in state court. And that's it for today's Kelso Report. Have a great day in the law.